All right. All right, let's go ahead and get started then.
Yeah, I just want to thank everybody for agreeing to be on the call today and for giving us your time. Really appreciate it. Everybody at The Truth About Guns is very appreciative. And I'm going to turn it over to Louis Bonham, who's going to conduct the discussion this morning.
Very good. All right, welcome everyone to this after action report on the Supreme Court's hearing in the New York State Rifle and Pistol Association. We have a distinguished panel today from UCLA Law School. We have Professor Eugene Volokh. We have Professor Dave Coppell from the University of Denver Sturm College of Law and the Independence Institute. And we have Cody Wisniewski from Mountain States Legal Association. We may have Joseph Greenlee from the Firearms Policy Coalition joining us during the call. But since I know that a number of you have other requests to comment today, we want to try to go ahead and get this done. So I guess just initially, and let's start with you, Professor Volokh. What are your gut reactions to the argument?
Well, the first gut reaction is never trust your gut reaction. It's always hard to tell for sure from oral argument where the justices are. Sometimes they're trying out ideas that they may not necessarily fully endorse. Sometimes they get persuaded, either at conference when they talk to each other about the case or when they exchange opinions. So, and there's certainly been examples where people thought from the argument the case would go one way, go another way. The best advice is patience. By pretty much almost certainly by July 1st, we're going to hear back from the court on the subject, and then we'll know what they thought. This having been said, I think that the intuition that people have these days wasn't always true, but these days, which is that the more conservative justices tend to have a broader view of the right to bear arms, and the more liberal justices have a much narrower view, seems to be probably borne out. And since the court right now is 6-3 conservative, it seems pretty likely to be 6-3 or maybe 5-4 in favor of recognizing some individual right to carry guns, with states being able to decide whether that'll be open carry or concealed carry, although almost all states, I think, these days would say if they have to, they're going to choose concealed as the requirement. And then leaving it to future cases to decide what limits there are on this. So for example, questions came up, what about university campuses? What about government-owned stadiums, where there may be 100,000 people sitting right next to each other? What about subways? And you can say the same thing about buses and other means of transportation. What about very, very crowded public places? The example was Times Square on New Year's Eve, or as one of the justices suggested, Times Square pretty much any time. So I don't think the court will say much about that, because it'll say, that's not the case before us. Let's lay out the big picture of the right, one way or the other. And then if it turns out there is a right to carry, then in that case, future cases will decide that. And of course, that's the way the court has progressed with pretty much all constitutional rights, right? When the court first started recognizing the First Amendment as a serious limit on government speech restrictions, it didn't say, oh, and here are all the rules, fighting words, obscenity, libel, everything, we're going to lay it all out today, like legislators writing a code. It was developed over the course of hundreds of decisions, and this may very well end up happening with the right to carry guns if the majority of the court does recognize it. It seems likely, though again, who knows?
Okay.
Somebody knows, but or at least they will know as of Friday, but they're not telling for a while.
They're not going to tell us for a while. Okay, Professor Coppell, what are your thoughts on it? Or Coppell, pardon me.
I basically agree with Professor Volokh.
Can we be on a first name basis here, by the way?
Okay.
I know that man is Dave. He knows me as Eugene. Why do anything else?
All right.
Well, maybe I'll call you Zur, or the some appropriate pronoun.
No. My pronoun is he.
Okay. I think he's right. Eugene is right that it looks to be a 6-3, and if you want predictions that outrun the evidence but are based on plausible speculation, I might suggest a 6-3 written by Justice Barrett, and something that maybe goes further than Eugene predicted, about sketching out at least some broad authority for states to declare certain places off limits for licensed carry, and to reaffirm the sensitive places doctrine and do it in some more detail than the Heller decision did. Because I think Justices Barrett and Chief Justice Roberts were among the sort of pro-Second Amendment side of the case, the ones most concerned by that. So if it's hypothesizing it's 6-3, Chief Justice Roberts gets to assign the opinion, and he might assign it to Justice Barrett. That's very speculative. I wouldn't bet your house on that on a 50-50 bet. But it's as long as we're here to speculate, it seems a plausible speculation.
Joseph, what are your gut reactions to the argument?
Well, I think it went pretty well. I think it's encouraging that Chief Justice Roberts and Justice Barrett seem to be trying to find kind of borders, locate where the borders would be around a favorable decision, which is encouraging. And it seemed like Justice Kavanaugh wanted to set a baseline as a shall issue, kind of a system in which there's objective standards that typical citizens can meet. And so I think it was all pretty encouraging signs. I think the counsel did a good job arguing. Mr. Frederick did better than I wish he had, which I think a lot was working against him. The text of the Second Amendment, the history and tradition, the Heller decision, and even the social science data. And but I think they all did a good job. But I'm feeling encouraged that it's going to be a favorable decision.
All right, Cody, what are your thoughts?
I think it's really interesting that there was no even discussion of there not existing a right outside the home, right? That came up in the prior New York State Rifle and Pistol Association case when we were talking about the litigation against the city. But here, it was almost assumed that there was some level of right, and the argument was really over how much regulation would be allowed on that. And so I agree with the other panelists. I think it's really interesting, especially with what Joseph said, that we're kind of testing the limits here. It looks like Kavanaugh was really using the other shall issue states as his model. And this kind of reiteration of the sensitive places doctrine and how that may or may not work. That being said, I also agree that I think the United States, Clement did a great job arguing. Underwood, took a lot of these issues on dealing with the facts as they were on the ground. And then the United States came out and sounded incredibly reasonable in their position. And, as a courtroom advocate, right, you always want to sound reasonable, and coming in with this blend of the text, history, and tradition test to then inform the levels of scrutiny, I think is going to be something that we'll probably see come up in the opinions. But again, like Dave said, reading the tea leaves at this point, don't bet your house on it. But I would be interested to see if any of the justices glom onto this idea that the text, history, and tradition of public carriage shows a level of a reasonableness test that was applied, and thus we should apply intermediate scrutiny here. I would not be surprised if that comes up.
Well, given that, again, I think as Eugene pointed out right up front, excuse me, we've got the three kind of the blocks that have been in place where you have Justices Thomas, Alito, and Gorsuch pretty well apparently set. And then, of course, Breyer, Kagan, and Sotomayor pretty much set. And so the focus becomes the three in the middle. Let's go backwards. Cody, how do you see, from trying to read tea leaves, because that's what we're trying to do here, how do you see the three of them coming out, the three in the middle on this?
Yeah. And so, we'll see how it all shakes out. I would guess that you're going to have a 6-3 opinion. So for those that aren't aware, the way that opinions are assigned at the Supreme Court is the majority assigns out the opinion to one of the justices is in the majority that gets to write the opinion. If the Chief Justice is in the majority, he gets to assign who writes the opinion. If not, it goes down to the most senior justice in the majority. In this case, that would be Justice Thomas. It's hard for me to imagine the Chief Justice will allow for a 5-4 in which Justice Thomas has the authority to assign the opinion. And I would love for that to happen and Justice Thomas just to self-assign it and let's see what happens. I think that's fairly unlikely. So you're probably going to get a 6-3 with the Chief Justice assigning it out. Dave makes a really good point about this potentially going to Barrett, and I'll let him follow up on his point there. I think you could also see it going to Kavanaugh, although here Kavanaugh expressed more interest in the text, history, and tradition test than I necessarily expected. In his Heller 2 opinion, his dissent, he basically talks about applying the text, history, and tradition test from Heller, but he does so in a way that says, look, this is the test that the Supreme Court set forth. We're just a mere circuit court. We have no choice but to set it forth. He doesn't advocate for it all that strongly. And in argument, he seemed to be much more excited about advocating for it. So before argument, I would have guessed Kavanaugh would be the person writing the opinion. But I think Dave might be able to convince me that Barrett will actually be the justice that writes it.
Okay. Joseph, what are your thoughts on the three in the middle?
I thought Justice Kavanaugh was maybe the strongest, seemed the most in favor of the Second Amendment out of anyone questioning. He first articulating his text, history, and tradition test. He really emphasized that we should focus on the text, and then if that doesn't give, only if that doesn't give the answer, then look to history and tradition, which is hard for anyone if you're arguing against the right to bear arms. It's hard to get around the text. So he seemed to be the one that most focused on what the actual text says and wasn't terribly concerned about history and tradition, especially getting into the 19th and 20th centuries. And then, Justice Barrett and Chief Justice Roberts just seemed to be trying to figure out where they could draw the line. Is it universities, stadiums, large public gatherings? And I think those are all encouraging signs.
Okay. Dave, your thoughts?
The anti-rights side, Bruen and his allies, did a really good job of coordinating their briefs and then the amicus briefs, and you really see a lot of common themes coming through from the top amici on the New York State side, and they clearly made, I think, a wise strategic decision to aim at those three justices in the middle. And to read the briefs, you would think Justice Kavanaugh and Justice Barrett before they became justices were the greatest expounders of the Second Amendment the world has ever seen. And then they tried to argue that, and therefore your theory should lead to upholding this New York law. That plainly didn't work on Justice Kavanaugh, who has been a swing on other cases. But I think the oral argument puts him very solidly in support of the right to bear arms here. And taking into the caveats that you can't always predict from oral argument, that seemed to be where Justice Barrett's going as well. Is there's got to be a right that can be exercised by normal people under normal circumstances, like when you're walking to the grocery store in Rensselaer, New York. And I think the overt appeals to Justices Barrett and Kavanaugh were also implicit to Chief Justice Roberts, and he seemed to end up in about the same place as Justice Barrett, which was concerned about sensitive places, but also recognized there's got to be some kind of real right for people to exercise. And a real right doesn't mean only when you're going camping or hunting.
Professor Volok, your thoughts on the three in the middle?
Well, yeah, we say that they're in the middle because in other cases they've been in the middle, but different justices are in the middle in different places. So I do think Justice Kavanaugh seems to be pretty firmly in favor of, again, recognizing a right to carry guns in most public places, but reserving judgment on how you can limit it in particular ways. I think the Chief Justice Roberts will also seem pretty solid on that, and Justice Barrett probably too. We know a little bit more about Justice Kavanaugh simply because he had written quite a bit on this in the DC Circuit, not on this particular question, but on the follow-up to Heller, and he seemed inclined to read it quite broadly. I think this is a situation where really it is a 6-3 court, and the question is, will some of the six peel off for reasons of their own, which may not relate to how conservative they are, which is just shorthand for views on a bunch of issues. We're guns may not be exactly the kind of issue that makes them conservative. Again, I think on balance today, it looks pretty likely that probably all six, I'd say at least five, will vote the right way. But one thing that's worth remembering is this wasn't always a conservative liberal issue, right? You go back to, I think, the 60s and the 70s, you have, I think, quite a lot of conservatives, tough on crime conservatives, saying, yes, we want the police to be able to police without worrying about supposedly law-abiding citizens having guns and interfering with that. That was, I think, an excellent point, rhetorically excellent, that I believe it was the lawyer for the federal government made. But in any event, to say, look, this is something that I think was in response to a question from Justice Kagan, who knows her colleagues and has a sense of how you can get to them if you can, is, well, what about police officers? I think a lot of conservatives are quite fond of police officers still. And on the other hand, in the 60s and 70s, you had both, say, Hubert Humphrey, who spoke out in favor of the right to bear arms, and of course you had the Black Panthers, who were exercising the right to carry, and unfortunately it led to some restrictions on carrying in Mount California. So it's interesting how the politics has pretty sharply gelled over the last few decades on this, and both in the public at large, but also among ideological characterizations on the justices. But it does look right now like we're going to see a pretty traditional conservative liberals.
Okay. There was an article I read, I believe, yesterday by one of Justice Sotomayor's clerks, and it pointed out something that a number of commentators have, and that is that when the Supreme Court granted cert, they rewrote the question presented and, looked to be possibly taking it from a facial to an as-applied challenge. Again, I'm curious as to your read on whether or not you saw any indications of that in the argument. Cody, if you'd start on that first, if you could, since we have a lot of listeners who are not constitutional law mavens, can you tell us first briefly what the difference between a facial challenge and an as-applied challenge is, and then kind of what your thoughts are on, on whether the argument gave us any clues on that?
Yeah, happy to. And I'll do my best not to embarrass myself in front of multiple law professors. So the difference between a facial and an as-applied challenge is essentially the question of the effect on the parties and then thus the effect of the court's ruling. So in a facial challenge, what you're challenging is you're saying that the statute on its face is unconstitutional, that there's no application of the statute that could be deemed constitutional because of various reasons. So thus, the court has to strike down the entirety of the statute. An as-applied challenge is slightly different. It's basically limited to the facts as that statute was applied to the individuals before it. And so the question is, the two individual people who live in outside of New York City in a different county, when New York applied and used this statute to deny them general concealed carry permits or unrestricted concealed carry permits, did it violate those two individuals' constitutionally protected rights? So it's a little bit more of a limited construction as opposed to a broad construction. And then in those as-applied cases, you have to take the facts of that scenario. If you were to use an opinion from an as-applied challenge, you would need to take those very specific facts and apply those to future facts and future cases, rather than just looking at the case broadly and saying, overall, this statute or this type of statute was ruled unconstitutional. So hopefully that's a good description. But I did think it was really interesting when there was the question presented switch. And so essentially the question presented switched from this, whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens. And then the court reframed that and basically changed it to whether the state's denial of petitioners' applications violated the Second Amendment. And so it switched it from broad into this narrow of these two individuals. Now, it kind of came up a little bit in argument when we were talking about the differences between counties and the locality in and of itself and the rural nature or the non-rural nature of where these particular individuals lived. But in our live blog, I noted it. I think it was Justice Breyer finally asks the question of, well, we're obviously not talking about New York City here, right? In which he asks to the New York State SG. And she responded, well, of course not. I don't know how we could be, and then moves on. What they're saying there is that if this is an as-applied challenge to these two individuals that don't live in New York City, then obviously we're not talking about the application of this law in New York City. It was such a throwaway question. It was at the end in the round robin. It's hard for me to see that any of the other justices really found this to be an as-applied challenge, and that they're not going to get at the constitutionality of the statute itself. I wouldn't be surprised if that comes up, if this is a 6-3 with the more progressive leaning justices dissenting. I wouldn't be surprised if that comes up in the dissent, maybe even in a separate dissent by Breyer, which says, look, we went too far. We should have limited this to the facts before us. Sotomayor had a statement about that as well. But I don't really think it's going to, after hearing oral argument, I don't think it's going to affect the overall ruling of the court, the majority opinion.
Can I chime in a bit? I've recently discovered the lawyer's true superpower, and that is we have the power to turn every question into a question about procedure. And one of the way to do it is by talking about appellate procedure and kind of the procedure of constitutional challenges. Do we label it as applied? Do we label it as facial? And often it's really important, and litigators totally focus on that very question, both when crafting the initial complaint and when writing the briefs. But as a practical matter, if there is an individual right to bear arms in public, then it's hard to see how it could be constitutionally limited by a regime that says basically people who have ordinary interest in self-defense, which is to say 90% of the people, almost by definition, because that's the ordinary people, don't have that right. So it may be cast as a as-applied decision that these particular challengers win, but precisely because they're not really that sharply different from other challengers, it's pretty obvious that that kind of decision would have an effect on tens of millions of ordinary people in New York and presumably in other states like my own California. Now, of course, you might say it's a decision, or excuse me, it might end up being a decision that is, whether it's applied or facial, would leave a lot of flexibility or a lot of questions, let's say, unresolved. So you could imagine, for example, the court saying, the statute would not be permissible as to people who live outside of Times Square, outside of the super densely populated areas. But we'll leave for the future the question of what happens in the really, really, really big cities. That would be a very strange way to do constitutional law, but you can imagine that. So formally, it again may be an as-applied decision, but it's not like, well, so it's only limited to these particular challengers, because obviously there are lots and lots of other people who live outside of the really big cities who are in exactly the same position as these challengers. So every so often you get a genuinely as-applied claim. So somebody might say, there's a child pornography ban, but the reason that I possess child pornography is I'm a lawyer in a child pornography case, and I have a really important reason connected to my client's right to counsel to have access to this, let's say. So you can imagine that's truly an as-applied challenge for kind of the rare exception. I just don't see, I don't see that happening here. Either the challengers will lose, in which case pretty much everybody else in their shoes will lose too, or they will win, in which case pretty much everybody else, or at least tens of millions of people who are in their shoes will win too.
To follow up on that, I think Eugene's analysis is right. But since we're speculating, let me sketch out something like that, but then apply it with some twists to the New York State. The plaintiffs here are in the same position that Dick Hetler was in Washington, D.C., where he was saying, Supreme Court, all I'm asking is let me register my handgun under the existing laws of the District of Columbia for registering handguns. Here, the plaintiffs are essentially saying, no, we got nothing against the New York law overall. Our big complaint is just the law says proper reason to be issued a carry permit, and we think being a law-abiding American who wants to exercise Second Amendment rights for lawful defense, that's a very proper reason. but we're not challenging other parts of New York law, such as sensitive places. So as Eugene says, yeah, you give the defendant a win on that way and say, well, as applied to these guys, they're typical Americans, and so yes, it may be as applied, but it's generalizable. However, in New York State, your permit issued by Rensselaer County or Albany County or lots of other places doesn't count in New York City. So you could imagine the court threading the needle. Let's give the plaintiffs an as-applied win. They get their permits because they've got proper reason, namely the Second Amendment, and everything else in New York is unchallenged and intact. So you can't carry on railroad lines, which is one of the New York sensitive places. And by the way, you can't carry in New York City. And then if it comes down in that way, then in the recalcitrant holdout jurisdictions like New Jersey or Hawaii, then the places, Honolulu is going to be saying, well, we're the New York City of Hawaii. And so even if people in rural Maui have to be issued carry permits, that doesn't count within Honolulu. And the same point for northern New Jersey would say, well, not only is Newark the New York City of New Jersey, but so is the whole metropolitan megaplex in that area.
Yeah, so this is the reverse Frank Sinatra principle, which is with regard to New York, is that if even if you can make it anywhere else, you might not be able to make it there.
Right.
Just consistent with the song, right?
Yes.
True.
I would love to see the brief from New York City arguing that neither Honolulu nor northern New Jersey are anything like New York City.
They would have to do it.
None of their business.
Patriotism.
Joseph, any comments on as applied versus facial?
I mean, just that I think I agree largely with Dave in that I think the original question as presented would have left open too broad of it left open possibilities of a holding that left the lower courts in kind of greater confusion about what standard's okay and what's not. And I'm going to go back to the shell issue. I felt like at the time, by narrowing the issue, the court intentionally left in place the possibility of keeping a shell issue regime. So just like in Heller, how the court said, well, assuming he's not otherwise prohibited from possessing firearms, you have to give Mr. Heller a license to carry around his home and to be able to register his gun. And I think that same type of holding is now possible in this case, where they can say, assuming the individual plaintiffs are not prohibited persons and they meet the objective portions of the New York licensing scheme, then you have to grant them licenses. But I'll add that I've heard a few different theories about why they changed the issue presented, and I hadn't really heard that before, so I might be pretty out there on that.
Okay, like I say, I brought it up because there were a lot of, and again, a lot of this is frankly from the media and a lot of, shall we say, non-legal reporters that were taking it as a major twist. And so that's why I was curious as to what your thoughts are on it. I'd like to also now direct your attention a little bit in this, particularly to Joseph and Cody, since for those of you that are tuning in, Joseph and Cody are in the trenches fighting these kind of cases. And kind of your thoughts, and we'll start with you, Joseph, in terms of, what will the next, we'll get a result on this. What is likely going to be the next battleground or the next major fight going forward?
I think, like, you mean the next big issue that's going to confront the Second Amendment? Well, I guess
Correct.
Anyone who appreciates the right to self-defense. I think the so-called assault weapon issue is unavoidable. It's just the most popular rifle in America, getting more and more popular every day. And I don't think that the court can avoid that issue for too much longer, just considering how many people cherish that firearm, that particular type of firearm. And then every time the gun manufacturers find a way to make something California compliant, for example, California comes in with a new way to prohibit those. And it's just it seems to be a never ending game. And that eventually the court will have to address.
Okay. Cody, your thoughts on what the next battleground is going to be, and again, we'll see what they come out with. But where do you think the next stones will fall?
I think come June, my life will be busy no matter what the court decides. But no, I agree with Joseph. I think that this, the ban of certain types of rifles and pistols and shotguns is going to jump back into the forefront. We at Mountain States Legal Foundation at the Center to Keep Bear Arms, we have some active litigation surrounding a ban of that type in Boulder in Colorado. So I imagine that that's going to become relevant again, and that will come to the forefront. I think the other side that we're really going to see is the definition of what constitutes a firearm. So we're seeing that go on with ongoing litigation that we have in California and in New York. But then you're also seeing that with Department of Justice and ATS rulemaking to kind of redefine what a firearm is and to redefine or specifically define a frame or receiver. So I think that that's going to pull it a little bit out of this realm. We're not going to be dealing with the pure Second Amendment constitutionality question. We're going to get a little bit into administrative procedure law, which is a little bit different than kind of standard federal court litigation over direct constitutionality. But I think those two areas will be particularly relevant. But again, if the Supreme Court establishes and firmly establishes the appropriate test for reviewing these Second Amendment cases, which seem to be at the forefront of a lot of different justices. Justice Gorsuch jumped in to talk about that. Justice Kavanaugh was talking about that. Even Breyer brought it up in some of his questions. That test and the change there is going to really change what the kind of realm of Second Amendment jurisprudence is across the nation. Dave can talk a little bit about, he and Joseph actually have done articles looking at how the circuit courts are applying Heller and how they're avoiding the application of Heller. And a lot of that's going to change if the Supreme Court is very explicit in this opinion.
Dave, I guess I was going to turn to you on that and kind of direct it a little differently. Of course, we've had lots of courts essentially, shall we say, wink at Heller for lots of different ways. Going forward, do you see that continuing? Do you expect to continue to see, shall we say, resistance to try to read the decision as narrowly as humanly possible in certain circuits?
Oh, sure. And that will go on whether or not the Supreme Court says stop doing intermediate and or strict scrutiny and instead use text, history, and tradition, because we, for some of the pro-gun legal advocates, text, history, and tradition has been this kind of holy grail because they think they win all the time, which they should win often on text, history, and tradition accurately applied. But we've also seen through the briefing here, it's possible to throw up a lot of smoke and sand, and skilled lawyers on the anti-gun side can find lots of history and tradition on their side, especially if one doesn't necessarily have to check the footnotes, and not all judicial opinions do. On the broader thing of what comes up, Chief Justice Roberts clearly is very concerned about preserving the political capital of the court as an overall institutional matter and not doing decisions that are going to annoy everybody in the public. So he was willing to go, it seems, to the top line on the gun issue. Heller, do you have a right to keep the most common handgun, the most common type of firearm that people keep for protection? Do you have actually a right to own that in your house? Well, yeah, and DC's law was eccentric, and he did that. And then we have Mcdonald versus Chicago. Well, the 14th Amendment, as it's developed, makes just about all of the Bill of Rights applicable to the state and local governments, and Americans are shocked when they find out that there's still a few things that haven't been applied. And so he goes along with that and says, yeah, you got to follow, it's just like most of the rest of the Bill of Rights. States got to follow it. And here, I think you can say, yeah, of course you've got a right to bear arms. That's in the text. And it can be and that can't be generally denied to the typical population. Beyond that, I don't know. And he's got a political capital problem coming from another direction, because the Trump administration's bump stock ban, and this is not a Second Amendment issue. You ain't going to win a case saying there's a Second Amendment right to bump stocks, but there are good lawyers saying you got a good chance of winning a case on the bump stock ban just because it contradicts the actual statute on which it's premised. And if, the Sixth Circuit hypothetically or some other court rules, I think in sort of the standard administrative procedure way, yeah, of course, Congress could ban them tomorrow, but the Bureau of Alcohol, Tobacco, and Firearms and Explosives can't ban them by saying that they fit under the particular statute when they really don't. The Supreme Court has to take it, and they'll be saying, hey, look, guys, this is just administrative procedure. You can definitely ban this stuff, but it still would use up a lot of the political capital, because folks, Dick Durbin would be on the floor of the Senate saying, and our radical extremist Supreme Court is now getting ready to legalize bump stocks. Just shows how crazy everything is. We got to pack the court tomorrow. So that all indicates to me maybe Chief Justice Roberts, at least, will want to be reticent about taking more Second Amendment cases soon.
Okay. Professor Volok, we're getting close to the end of our time on this, so I'll let you have the last word. What's your, thoughts on what comes next, and any final, kind of comments on today's argument?
Well, if the court says there is an individual right to carry guns in public places, at least as a general matter, there's going to be a lot of litigation about what that covers, because I think a lot of conservatives and a lot of even gun rights supporters would balk at it in some places. Certainly judges would balk at it in courthouses. Maybe they shouldn't, but they would. And likewise on airplanes. So you could say, well, and this was a suggestion from one of the justices, well, if there are metal detectors that effectively protect you from attack there, then you don't really need a gun there. So that's a possible distinction. Maybe it might distinguish some other places, like some stadiums. It may distinguish a few schools. Thankfully, a lot of schools don't have metal detectors. So then one interesting question is going to be, what do you do about that? One suggestion was that from Paul Clement is you've got one possible principle is it open to the public or only to a small portion of their ticket holders? Well, what about public transportation? And I think it's a pretty good argument that if you need to be able to protect yourself in public and you don't have a car and you have to take a bus somewhere, then you need your gun there in the place that you arrive at, unless the bus has a gun check at the entrance, which I doubt bus companies will. But that's going to be an issue that I think various people are going to have to, or various lower court judges are going to have to consider, and there may be disagreements. So there's no doubt that if you want to keep things simple, then the answer is just say no right to carry in public places. There's going to be some extra complications as a result of that. And I think the justices seem prepared to accept that, just because that's part of the cost of having a constitutional right, is you're going to have a lot of cases. But I think the key cases, the main cases that are going to be coming out are that. There's also a controversy that's quite independent of this, but actually maybe not entirely independent, about 18 to 20-year-olds and their Second Amendment rights. So far, the debate has been chiefly about whether they have a right to buy guns. They're, of course, limited under federal law from buying handguns from gun dealers, and some jurisdictions categorically ban them from acquiring guns. And I believe New York City is one of them. But now there's going to be also a question about what about concealed carry rights for 18 to 20-year-olds. Because my understanding is a lot of the shall issue states set 21 as the cutoff. Not all, but a lot do. So there will be extra dispute about that too. I will say there's no doubt there's going to be more debate about bans on particular kinds of guns, like assault weapons. I think bans on so-called assault weapons are a pretty foolish idea, but in part because calling something an assault weapon doesn't really make it that much different from most other weapons. But the flip side is also, it's not as much of a burden on people's ability to defend themselves. I mean, people may be really upset that they can't get a particular gun that they like, but the bottom line is they get lots of other guns that are just as good. The key thing about the concealed carry, or let's say the public carry issue, is that there are no substitutes really. So this is an issue that really goes to the heart of people's ability to defend themselves in a way that the assault weapons controversy, important as it is, does not. So I think we're going to see, if the court rules in favor of again, a right to public carry, we're going to see a lot of follow-ups and just what kinds of restrictions are allowed.
Yeah, I know that the Firearms Policy Coalition has already got some test cases in the hot already, I think, under sale on the 18 to 20-year-old thing, but lots more to come in the future. All right, again, I thank everybody for giving us your time and your counsel today. And with that, we will sign off.
Thanks very much.
Okay.
Thank you.
Okay, we can cut it from there. Okay, thanks, everyone.
Thanks.